Committee will come to order. Pending business is the amendment of nature substitute offered by the gentleman from Texas, Mr. Gill, who seeks recognition. Question occurs on the amendment in the nature of a substitute offered by the gentleman from Texas. All those in favor say aye. 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 Those opposed to the legislation? No? Looks like the ayes have it. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. Roll call being requested. Oh, that's right, that's right. All right. With that, the opinion of the question is now on the adoption of the amendment in the nature of substitute. I'll get there. The opinion of the chair, the ayes have it. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported in favor to the House. Now they want a roll call vote, which is in order. So the clerk will call the roll, and we will start working on members.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. McClintock?
We got guys on the...
Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden, Mr. Van Drew, Mr. Nels, Mr. Moore. Mr. Moore votes yes. Mr. Kiley, Ms. Hageman, Ms. Lee, Mr. Hunt, Mr. Fry, Mr. Grothman. Mr. Grothman votes yes. Mr. Knott. Mr. Knott votes yes. Mr. Harris, Mr. Onder, Mr. Schmidt. Mr. Schmidt votes aye. Mr. Gill. Yes. Mr. Gill votes yes. Mr. Baumgartner. Mr. Raskin. Mr. Nadler. Ms. Lofgren. Mr. Cohen. Mr. Johnson. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Ms. Jayapal votes no. Mr. Correa. Ms. Scanlon. Mr. Nagoose, Ms. McBath, Ms. Ross. Ms. Ross votes no. Ms. Ballant. Ms. Ballant votes no. Mr. Garcia. Mr. Garcia votes no. Ms. Kamlager-Dove. Mr. Moskowitz. Mr. Goldman. Ms. Crockett. Ms. Lee. Ms. Lee votes yes. Mr. Fry, you're not recorded. Mr. Fry votes yes. Mr. Gooden votes yes.
While we're waiting, I see we've been joined by one of our former colleagues, Mr. Perlmutter from the great state of Colorado. Glad to have you.
Mr. Johnson, you are not recorded. Mr. Johnson votes no. Mr. McClintock votes aye. Mr. Nels? Mr. Nels votes yes.
Troy Nels. Gentleman from California.
Mr. Correa votes no.
What? Gentleman from Missouri.
Mr. Onder? Mr. Onder votes yes.
Gentlelady from Pennsylvania.
Ms. Scanlon, you're not recorded. Ms. Scanlon votes nay. Mr. Isa, you're not recorded. Mr. Isa votes yes. Mr. Fitzgerald votes aye. Mr. Harris, you're not recorded. Mr. Harris votes yes. Mr. Hunt? Mr. Hunt votes yes. Mr. Baumgartner? Mr. Baumgartner votes aye. Mr. Chairman, there are 17 ayes and 7 nays.
Excuse me, the ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 4711, the Remove Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 4711.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Texas, Mr. Nels, for an opening statement.
Thank you, Mr. Chairman. Today, we are living in a new era of American history, a golden age under President Donald J. Trump. There is peace in the Middle East. American businesses are thriving. The economy is roaring. Law and order has been restored. The border is secure, and immigration laws are being enforced. God bless Donald J. Trump. Our allies respect us. Our enemies fear us. Criminals and terrorists and other bad actors recognize that they have no safe haven here, especially the bad hombres on the drug boats in the Caribbean. People around the world know that they can no longer exploit our laws, cross the border illegally, take advantage of the American people, and be rewarded with long-term residence in the United States. This is all a far cry from the absolute anarchy unleashed on the American people by the last administration. 2021, Joe Biden, Kamala Harris rolled out the red carpet for the entire world, opened our borders, watched terrorists, criminals coming in, terrorists, gang members, everybody coming into the United States. Come on, we're open. We predicted the results, even here in this committee. The Democrats were silent, or even worse, they were cheerleading the systematic destruction of our borders. When the Republican called out these obvious insane policies, Democrats accused us of racism and xenophobia. They said we were fear-mongering. When we proposed legislation to fix the problem, every single Democrat voted no. They voted no. The consequences were expected. Crime and destruction and chaos reigned supreme. After 4 years of Democrats' open borders, the American people were fed up. In a historic election 1 year ago, the American people spoke loud and clear. They elected Donald J. Trump and Republicans in the House and in the Senate on a mandate to make the immigration system work for America first. In 11 months, President Trump fully secured the border and actually began to enforce the immigration laws. Think about that, enforcing our nation's immigration laws. There's a lot of work still needs to be done. Millions of illegal aliens remain in the United States. So consider this. 3 months before the Joe Biden took office in 2021, the immigration court case backlog was 1.5 million cases, 1.5 million. After 4 years of border chaos and complete lawlessness, that backlog exploded to 4.2 million cases, nearly tripling in just one presidential term. That backlog is a direct consequence of the Biden-Harris border crisis. As the border crisis raged, the immigration courts received 1.2 million new cases in fiscal years 23 and nearly 1.8 million new cases in fiscal year 24, compared to 1.9 million new cases received from fiscal years 2015 through 2020 combined. The backlog is a key part of the Democrats' open borders plan to ensure that illegal aliens can remain in the United States indefinitely. That's what they want. Practically speaking, what does that backlog mean? It means that an illegal alien remains in the United States for years as they await a hearing before an immigration judge. Of the asylum cases that were adjudicated in fiscal year 23, only 14% resulted in an asylum grant, and only 12% of asylum claims granted in fiscal years 2024. So 12 and 14%. The other 87% coming over, they have no claim. They're just coming over. They're coming over and they want to stay here. They have no claim. Despite this, doomed cases languish in immigration courts for years, which incentivizes aliens to file frivolous applications, as they know they can remain in the United States for years and years to come. Who wouldn't take advantage of that stupidity? Well, millions have, and the American people are paying the cost. Just ask the families who have died at the hands of illegal criminal aliens, including those that are driving commercial trucks in our highways. Makes no sense. According to Democrats, if a foreign national stays in the United States illegally long enough, they suddenly become too sympathetic to deport. We're already hearing this rhetoric about aliens who came into this country during the last 4 years. They've lived and worked here for years, Democrats say. Well, of course they have, because Joe Biden let them all in and then didn't deport anyone for years. To my Democrat colleagues, let me make this very clear. An alien living illegally in this country for years doesn't mean that alien gets to stay here forever. It just means they should have been deported sooner. Should have been deported sooner. That's what this bill does. The Remove Act states that if you're here illegally, you must be placed in removal proceedings as expeditiously as possible. If you commit a crime that makes you more deportable, you must be placed in removal proceedings as expeditiously as possible. And once those proceedings begin, they must be completed within 15 days, 15. No more hanging out in the United States, committing crimes and taking advantage of public benefits for years while your fake asylum case is pending. No more gaming the system. You're an illegal alien. Your case is heard quickly, and if you don't have a basis to remain in the United States, you're deported, plain and simple. And that's what this bill does, and it's only common sense. Before Democrats falsely claim this goal is too lofty and too unrealistic, let me remind them about one of the Republican signature achievements from just a few months ago. Through President Trump's one big beautiful bill, the nation's immigration courts are now flush. They're flush with cash. They are funding to hire immigration judges who can hear cases more quickly. The one big beautiful bill also included new statutory fees for asylum applications and other commonly filed applications and appeals. Some of that revenue is directed back to the immigration courts. For maybe the first time in history of this country's immigration courts, resources are not the problem. This bill puts those resources to good use, America First use. Meanwhile, President Trump already has revived the failed courts after Joe Biden's destruction. President Trump's immigration court leadership finally empowered immigration judges to dispose of frivolous applications in which the facts clearly do not establish eligibility to remain in the United States. And we know that under Democrats' dream of open borders and limitless immigration, that immigration court proceedings aren't over until the alien wins. Imagine that. We got to do it in the ends when the alien wins. We're here to promote a different dream, one that prioritizes aliens with valid claims to remain in the United States and the American people. The Trump administration is already doing everything it can to ensure bad hombres are removed from the America's streets. The bill gives the president yet another tool to deport illegal aliens quickly by speeding up the legal process. The Remove Act injects common sense into the immigration system, and I urge my colleagues to support it. I yield back, sir.
Gentleman yields back. The chair now recognizes the gentlelady from Vermont, the ranking member, for an opening statement.
Thank you, Chairman Jordan. I'll be reading the remarks for our ranking member who is still on the floor. The Remove Act is yet another Republican bill aimed at stripping away due process for immigrants. The bill arbitrarily requires that all immigration court proceedings last no longer than 15 days. This is a fundamentally unserious idea, completely divorced from the reality of our immigration courts. It would result in an immigration court system that lacks due process protections and prioritizes speed over fairness and justice. Given the current state of the immigration court system, it is not humanly possible to properly and fairly adjudicate removal proceedings in 15 days. Immigration judges are already dealing with crushing caseloads. Forcing them to adjudicate cases on a sped up timeline will only result in mistakes and incorrect decisions and will deprive individuals of their fundamental rights to due process. Immigration courts have long suffered from inadequate resources and significant case backlogs, but these problems have only worsened in recent years. Since 2015, the immigration court backlog has more than quadrupled in size and now sits at approximately 3.8 million cases. The Trump administration is also firing many experienced immigration judges and is seeking to replace them with temporary and inexperienced immigration judges. At least 139 immigration judges and court personnel have reportedly been fired, transferred, or have taken buyouts since January 2025. As of July 2025, there are only 685 full-time immigration judges. Although, as my colleague from Texas claimed, the One Big Beautiful Act, you said it meant that we are flush with cash in the immigration court system. It does provide funds for hiring immigration judges, but it caps the total of immigration judges at 800, which is far short of the number that is needed. Experts estimate that it would take 1,300 immigration judges to work through the backload over the course of a decade. Moreover, immigration law is considered by many to be the most complex areas of federal law, second only to the U.S. tax code. Individuals in removal proceedings may have a valid legal basis to remain in the United States, but no way to properly articulate this to an immigration judge without the assistance of counsel. In fact, according to a University of Pennsylvania Law Review study, only 5% of immigrants who won relief from deportation in the time period of the study did so without the help of an attorney. Imposing a 15-day requirement on the completion of removal proceedings is akin to denying people their day in court, which violates our bedrock principles of fairness and due process. It leaves non-citizens with little time to find a lawyer and leaves lawyers with no time to competently prepare a case. Today, it takes an average of 4 years for non-citizens to receive an asylum hearing, and final decisions can take much longer due to appeals. Now, those averages are way too long. We need to find a way to speed up the process while ensuring that it is fair and equitable. We must be able to determine who's eligible under law to stay in the United States and remove those who are ineligible much more quickly. But this bill, which provides no resources, no plan, and no process, is not actually a solution to the problem that we have. And I do not doubt or question the intent of Mr. Nels in bringing forward this legislation. I think we share the goal of deciding these cases more quickly. But forcing immigration judges to decide complicated and consequential cases in a matter of days is not the answer. Rather, Congress should reform our immigration system and appropriate the resources necessary for cases to be resolved fairly, efficiently, in a timely manner. We also need to find a way to make immigration judges more independent. For far too long, immigration judges have been subjected to an ever-constantly changing set of policy priorities from both sides of the aisle and have not given enough protection from losing their jobs. Given the life and death decisions the judges have to make every day, we need to ensure they have the adequate independence to do their jobs. I hope my colleagues will work with us to address some of the areas where this bill falls short. However, at the end of the day, I think we need to start over with this one. I urge my colleagues to oppose this short-sighted bill, and I yield back.
Gentlelady yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Texas to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature
Without
of...
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair now recognizes the gentleman from Texas to explain the amendment.
This amendment makes technical changes to the bill and ensures aliens are placed in removal proceedings as expeditiously as possible. I yield.
Gentleman yields back. Who seeks recognition? Gentlelady from Washington is recognized.
Mr. Chairman, I have an amendment at the desk.
The clerk will report. Point of order reserved by the gentleman from Arizona.
Amendment to the amendment in the nature of a substitute to HR.
Amendment will be considered as read. The gentlelady from Washington is recognized to explain her amendment.
Thank you, Mr. Chairman. I want to be clear about something. Our immigration court backlog today stands at 3.8 million cases. It takes someone the better part of a decade to finally have their day in immigration court. And this bill, without investing any resources in changing that system to rid the backlog first, just overloads an already overloaded system with a ridiculous 15-day timeline. That's why my amendment would require the Executive Office of Immigration Review to have the necessary number of immigration judges and support staff in place to actually adjudicate all these immigration hearings before putting this absurd 15-day timeline in place, to at least try to ensure that this bill is implemented in a slightly more responsible way. We all know that the current backlog and wait times are way too long and unfair to the people who have legitimate asylum claims or other claims for relief. We all understand and agree that it doesn't make sense for people without a legitimate claim to be in the United States for years, and that is something that we would work collectively on with the other side. It's also why, when we were in the majority, Democrats tried to move legislation that would actually make the real structural reforms that our immigration courts needed to work. We advanced legislation that would make our immigration courts completely independent to take politics out of the system. We worked to ensure that children have counsel so that they can navigate immigration court proceedings. No one wants to see children as young as 3 or 4 years old trying to defend themselves alone in any court. We fully funded the legal orientation program in detention, which actually makes our courts operate more efficiently by helping people better articulate their claims or even realize that they don't have a viable claim for relief. We need fair and orderly and timely adjudications of immigration court cases. Those are the kinds of reforms that we need to actually make the immigration courts function. But this bill does absolutely none of those things. Instead, it just places an arbitrary, unworkable timeline on all court cases. It is a completely unfunded mandate dedicating no actual resources to its implementation. Immigration judges face daunting caseloads. Over 100 judges have been fired or pushed out by the Trump administration, despite historic case backlogs. And we now have roughly 685 immigration judges, which is not nearly enough to handle current caseloads. It simply would not be possible for the existing number of immigration judges to handle adjudicating the cases in the backlog within 15 days from start to finish, let alone the new cases that are being added. So for this bill to be feasible, we need more judges. And in a cruel and harsh irony, that would likely require the Attorney General to waive certain provisions from the Republicans' big bad betrayal bill, which did cap the number of immigration judges at 800 starting on November 1st, 2028. But even that number, 800, would be woefully insufficient to carry out the requirements of this bill. None of this is the kind of thoughtful approach that we need. This is really the opposite. Even putting aside the unfunded mandate and the complete inability to implement this bill, it is the opposite of ensuring access to justice and due process. It's actually just bad policy. Remember that because immigration proceedings are civil proceedings, not criminal proceedings, there is no right to counsel in immigration proceedings. So just imagine that you are given a charging document that places you into removal proceedings. Under this bill, if you want to hire an attorney or find a pro bono attorney, you need to find one in a matter of hours. You need to figure out what form of relief you're going to apply for. You need to prepare for trial in one of the most complex areas of law in the United States, and you need to be prepared with testimony and witnesses before a seasoned ICE attorney. Under this bill, trials must commence, quote, as expeditiously as possible once the notice to appear is filed within the immigration court. And then you've got 15 days from the beginning of proceedings until the end. So to put this in perspective, the form to apply for asylum alone is 12 pages long. Asylum applications, which consist of affidavits, country conditions reports, expert testimony, primary source documents, and more, are often hundreds of pages long and can take months to compile. That's not to mention the trust that attorneys have to develop with clients to understand their relief claims. Imagine being a survivor of torture or sexual assault and having to relive all of that trauma with a total stranger in under 15 days. I sincerely hope my colleagues will consider accepting this amendment. It won't completely fix the bill, but it will go a long way to ensure that it's done in a somewhat more responsible way. I yield back.
Gentlelady yields back. Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. I oppose the gentlelady's amendment. She
Withdraw
mentioned.
your point of order. I think you had a
Oh,
point.
I'm sorry.
Withdraw his point of order.
Yeah, I withdraw the point of order. I'm sorry. Move strike last word.
Gentleman is recognized.
Thank you so much. And I oppose the gentlelady's amendment. She raised the specter of a 3-year-old going in to testify. Well, here's the way it works. If you were under the Biden administration, they would give you over to ORR. You would be placed with an unvetted sponsor, never to be seen again. Over 400,000, according to the Office of Inspector General. 58,000 of them under the age of 12. They never made it to their court dates for that little child. Why? Because they'd probably been trafficked. So while we're justifiably concerned about what happened in the Epstein case, I find it intriguing that the Democrats never bothered to raise this particular issue. It was always the Republicans. And that's when you actually had the ORR director come in to our subcommittee and admit she had no idea where more than 300,000 of those children were. She admitted that. But what happens now, which was supposed to happen then, is a guardian ad litem gets appointed to represent and manage the child's interest. That's what happens. So when you start talking about children, you better at least know what happens there. And so to support that, Mr. Chairman, I'll submit this article called DHS Inspector General, 448,000 unaccompanied kids transferred under Biden.
Without objection.
Thank you. Now, what else? What else has to happen here? Under the Biden administration, those of us who live along the border and spent many, many days and nights on the border talking to people coming in from over 165 different nations, from San Diego to McAllen. These individuals had no idea why they were coming other than they were told they could come in and receive basically life, a new life in America. That's what was happening. And the women were being trafficked and the children were being trafficked. And if you'd never seen rape trees, then you didn't get on to the border. You probably shouldn't be talking about this. It's real easy to talk about this stuff from off the border. It's not real easy to talk about it when you've been to the border and spend a lot of time on the border. And these folks, many of them coming in, literally millions and millions, which is why you have a backlog that went from about 1 million to 4 million. That's your backlog. And the reason that that's happened is because the previous administration let the world in and told them. That's why if you went over to Tijuana, you'd see in the square right there in the Zocalo, you're going to see people wearing "Let us in, Joe Biden" t-shirts. That's what happened. And these folks should be removed. You actually have more than 1 million people, probably about 1.5 million now, who actually have removal orders. But we've lost them. We've lost them. The Biden administration had like 1.2 million, and they didn't remove them. Because they said, well, you know, whether you have a removal order or not, we're not going to remove you. In fact, the Secretary of DHS at the time said, just because you have a removal order, if you don't have some other serious crime, we're not going to remove you. That vitiates the rule of law and undermines our sovereignty and undermines the very notion of a nation state. That's what happened under Joe Biden. I view what Mr. Nels is trying to do here as simply trying to move this thing forward and acknowledge that you have a major problem, and these folks who have come here illegally, and that is the term of art, they are illegal aliens, should be removed and should get their process as swiftly as possible, and then they can go back to their home country. With that, Mr. Chairman, I'm going to oppose this amendment. Yield back.
Gentleman yields back. Question occurs on the amendment offered. Gentlelady from California is recognized.
Thank you, Mr. Chair. Lord have mercy, what a day. So I do support the amendment, and I'm going to yield some time to my colleague from Washington State. But first, I just have to say we're talking about, I think, girls on the border and being trafficked. And I guess I represent a border state, California. And we have a corridor in my district called the Figueroa Corridor, where teenage girls, as young as 11, are being trafficked on the streets in all kinds of inappropriate wear, and sometimes not hardly wearing anything at all. And they're being trafficked by these pimps to pedophiles who are knowingly having sex with 11-year-olds and 12-year-olds and 13-year-olds and 14-year-olds. And sometimes they're girls and sometimes they're boys. And most of them are from the foster care system. And I'm gonna tell you something else. We have AUSAs, we have DAs that have been trying to work on getting rid of these traffickers, trying to help these young girls and young boys, trying to get rid of the prostitution and the trafficking happening on the corridor. But you know what's happened? Department of Homeland Security and Kristi Noem have called off these AUSAs and these DAs from working on these cases because they don't care about these girls. They want these people gooned up, running into churches, running into kindergartens, snatching parents and kids and detaining them unlawfully to deport them because somebody is looking for a TV show of terror. So I don't need nobody today talking to me about how we need to be trying to help some victims when you have prosecutors who've been working on these cases for years calling our office saying, can you do something? Because the case I've been working on, and I'm about to get these bad guys, I've been called off of because Homeland Security needs another TV show coming out of MacArthur Park. So give me a break. And with that, I will yield the rest of my time to Congresswoman Jayapal.
Thank you to the gentlelady from California. And with respect to my colleague from Arizona, maybe you've never been in a court where they have minor children who are there. Well, I don't understand how you could say it's not happening because I was in the court room at the hearing. I sat through the entire docket. It's called a kid's docket. And what's happening there is these kids who are 2 and 3 years old are hugging teddy bears and putting their head on the side of the pews, the benches, just trying to understand what's going on. And a judge is reading them their rights and saying, you have the right to be represented. I want to make sure you understand. You have the right to question the government. You have the right, blah, blah, blah. A kid, 3, 4 years old, is going to do that? That's not due process. That's a farce. And to my colleague from California's point, this article, this is an investigation by the New York Times. The department, dated November 16th, 2025, the Department of Homeland Security has diverted thousands of federal agents from their normal duties to focus on arresting undocumented immigrants, undermining a wide range of law enforcement operations in response to mounting pressure from President Trump. Homeland Security agents investigating sexual crimes against children have been redeployed to the immigrant crackdown for weeks at a time, hampering their pursuit of child predators. And federal efforts to combat human smuggling and sex trafficking have languished, with investigators reassigned to help staff deportation efforts. And it goes on to say that Homeland Security investigators worked approximately 33% fewer hours on child exploitation cases from February through April compared to their average in prior years. So please don't tell us that we don't care about kids who are sexually exploited or trafficked. That is ridiculous. And this bill makes no sense because it's saying you gotta overload the system when there aren't any judges to take care of it. There's no resources invested, and it makes absolutely no sense.
The lady's time has expired.
I yield back.
Is there further discussion on the amendment? Seeing none, the question is on the amendment offered by the gentle lady from Washington. Those in favor say aye. Aye. Those opposed say no. No. The noes appear to have it.
Vote, please.
Roll call is requested. The clerk will call the roll.
Mr. Jordan? Mr. Isa? Mr. Biggs? Mr. McClintock?
No.
Mr. McClintock votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Van Drew, you're not recorded. Mr. Van Drew votes no. Mr. Correa votes aye. Mr. Fry, you're not recorded. Mr. Fry votes no.
Clerk will report.
Mr. Chairman, there are 9 ayes and 10 noes.
The vote being 9 in the affirmative and 10 in the negative, the amendment is not adopted. Is there further discussion on the amendment in the nature of a substitute? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor say aye. Those opposed, those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended.
Could we have a roll call vote on that? Oh, that was an yes.
A&S. Question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no. The ayes have it. The bill is ordered reported favorably to the House. And now, Mr. Raskin.
Recorded vote, please.
Recorded vote has been requested. Secretary, call the roll.
Mr. Jordan? Mr. Isa? Mr. Biggs? Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Gooden votes yes. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgardner? Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Onder? You're not recorded. Mr. Onder votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Biggs, you're not recorded. Mr. Biggs votes yes. Mr. Fitzgerald votes yes.
Clerk will report.
Mr. Chairman, there are 14 ayes and 9 noes.
The vote being 14 in the affirmative and 9 in the negative, the bill is adopted. In order to be reported favorably to the House, members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 2189, the Law Enforcement Innovate to De-Escalate Act of 2025 for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 2189 to modernize federal firearms laws to
Without
account.
objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
Thank you, Mr. Chairman. The Gun Control Act, GCA, of 1968 was enacted to assist law enforcement in their fight against violent crime. Along with imposing stricter licensing and regulation of the firearms industry, the GCA also established a new definition of a firearm, which, according to the bill, includes, quote, any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. While that definition has been suitable to the firearms industry for the last 57 years, modern advancement in less than lethal technologies, such as tasers, have created a need for Congress to take a second look at the definition to ensure the GCA, as written, does not stifle innovation. It is also important in promoting transparency during law enforcement encounters. For example, if a less than lethal weapon, such as a taser, uses an explosive propellant to fire its projectile, which in the case of a taser is its barbs, it would be classified as a firearm despite its low probability of serious injury or death. And because that weapon is considered a firearm, if used during a law enforcement encounter, that use may be considered deadly force in 43 states across this country. This includes my own state of Wisconsin, which includes in its definition of deadly force the discharge of a firearm. It is an unintended consequence of a law passed long before advancements in less than lethal technologies that has led to fewer law enforcement agencies adopting more innovative tools due to their same classifications and restrictions as other firearms. Law enforcement agencies agree, and so do I, and so I would ask that the following letters of support be included in the record.
Without objection.
First, a letter of support from the International Union of Police Associations dated March 14th, 2025, a letter of support from the Hispanic American Police Command Officers Association dated April 18th, 2025, a letter of support from the Major County Sheriff's Association dated April 30th, 2025, a letter of support from the National Organization of Black Law Enforcement Executives, or NOBLE as it's called, dated May 23rd, 2025, and a letter of support from the National Fraternal Order of Police dated May 30th, 2025. These letters all agree that this change not only encourages more innovation within the less than lethal weapon space, but also promotes de-escalation during law enforcement encounters. In closing, I'd like to acknowledge that last Congress, some of my colleagues on the other side of the aisle took issue with certain aspects of the bill, including what they described as an overbroad exemption under the Gun Control Act. To those colleagues, I have taken your concerns seriously, and this bill has been revised to ensure the term less than lethal projectile device does not unintentionally carve out devices that could somehow be converted to handguns, rifles, or other firearms. The revised language in H.R. 2189 would no longer allow devices to be exempt under the CGA if the device is intended to expel or could be readily converted to accept or discharge firearm ammunition. This is in addition to the previous requirement that the device not exceed a velocity of 500 feet per second, and that it not be designed or intended to be used in a manner likely to cause death or serious bodily injury. I believe this tighter language will address any concerns of firearms being quote-unquote deregulated through this conversion to a less lethal device. I urge and hope that you can support this bill as revised, and I yield back.
Gentleman yields back. The chair now recognizes the ranking member, Mr. Raskin, for an opening statement.
Mr. Chairman, thank you very much. Unfortunately, I have to oppose my friend's legislation, which I still think would create a dangerous loophole in the Gun Control Act by exempting so-called less than lethal devices from laws requiring firearms to be traceable, detectable by security equipment, and not available to prohibited purchasers like felons. This new loophole would allow felons and other dangerous people to more easily access weapons without a background check that are untraceable and undetectable. This legislation does real damage by rewiring the definition of firearm throughout the entire criminal code to exclude certain, quote, less than lethal weapons, which may not be lethal but are still highly dangerous, such as taser guns, which have been identified as a contributing factor in more than 500 deaths in the United States. Because the definition of what constitutes a firearm is central to our federal firearm legal architecture, altering that definition is a dangerous and complicated endeavor and will have consequences that perhaps are not intended by the bill's proponents. The bill defines a new category of weapon, these so-called less than lethal projectile devices, and exempts them, which are currently classified as firearms, from all regulation under federal firearms laws such as the Gun Control Act. And these weapons, contrary to what the title of the bill might invite us to believe, would be exempted from federal firearms laws regardless of who uses, purchases, possesses, or manufactures them, creating an entirely new loophole in our nation's gun safety laws. For example, if enacted, this bill would allow persons who are not legally allowed to possess firearms, like domestic abusers and convicted felons, to legally purchase these dangerous weapons that are still designed to incapacitate and overpower their targets. The loophole created would not only allow domestic abusers and convicted felons, for example, to buy these weapons, but allow them to buy them without any background check at all. It would exempt them from the requirement that they have a serial number and are traceable so that law enforcement can identify their owners when they're used in violent crimes. It would also exempt them from laws requiring firearms to be detectable by metal detectors and the X-ray machines used at airports. If H.R. 2189 were to become law, nothing would stop a convicted felon from purchasing a taser designed to avoid detection and carrying that weapon past security onto a plane, into a school, or indeed into this building. This bill would make all of us a little bit less safe. Supporters of the bill argue that it's needed to update the Gun Control Act of 1968 to reflect modern technology and ensure that law enforcement can use these less than lethal weapons, but law enforcement agencies are already exempt from many provisions of the Gun Control Act, and law enforcement officers have long used so-called less than lethal weapons in the line of duty. Supporters also argued the change is needed because the classification of these weapons as firearms may result in the use of the weapon being considered deadly force, even though the device is designed to be less than lethal. But federal courts have distinguished between deadly force and intermediate force in cases involving law enforcement uses of less than lethal weapons, and states are more than capable of modifying their laws to account for these technologies if they believe that they should do so. There is no indication that state or federal law is out of step with the design and use of these weapons, much less that such a mismatch has prevented law enforcement agencies from adopting them. Organizations working to end gun violence, including Giffords, Brady, Everytown for Gun Safety, and the Community Justice Action Fund, all strongly oppose this legislation. But it's my understanding that these groups have offered to work with the proponents of H.R. 2189 to try to craft narrower language to advance the legitimate stated purposes of the bill. If the purpose of the legislation is really to help law enforcement agencies access less than lethal weapons, then we can help you achieve that goal in a way that mitigates the dangerous consequences of the bill as currently drafted. The gun safety groups proposed alternative language that would define so-called less than lethal devices and exempt them from being classified as a firearm under federal law when they are used by a law enforcement officer acting in their official capacity. Although none of these gun violence prevention groups favor changing the federal definition of firearm, they're willing to compromise to ensure that law enforcement officers are not somehow prevented from using these devices while also mitigating the potentially dangerous consequences of this bill. So we really should keep working on this in good faith. But as it stands, I do not believe we can risk creating a new dangerous loophole in our firearms laws, and I yield back the balance.
Gentleman yields back without objection. All other opening statements will be included in the record. The chair now recognizes the gentleman from Wisconsin to offer an amendment in the nature of a substitute.
Mr. Chairman, I do have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a
Without
substitute.
objection, the amendment in the nature of a substitute be considered as read and shall be considered base text for the purpose of amendment. The chair now recognizes the gentleman from Wisconsin to explain the amendment.
Yeah, this amendment simply removes the year 2025 from the title of the bill. In no way changes or alters the purpose of the bill. And I would hope that you would support the amendment.
Is there any discussion on the amendment in the nature of a substitute? Gentleman from California is recognized.
Thank you, Mr. Chairman. Move to strike the last word.
The gentleman is recognized under the 5-minute rule.
Thank you. First of all, I thank my colleague, Mr. Fitzgerald, for leading this bill. I just want to make a couple of important points. First of all, tasers save lives. The goals of using a taser is to reduce fatal encounters. The bill will also improve community trust by reducing injuries in the community when we have encounters. Clear classification standards and better recorded use of force events is also part of this legislation. I'll give you an example. When public safety officers pull a taser out of their holster, automatically a body camera will be triggered. If it's not an officer, It's if an officer, an individual out in a community discharging a taser, that taser will automatically modify the cloud of the time, date, and place of discharge. You don't have that technology right now. This bill will also enable other public safety groups to have the access to tasers. How? By clarifying current law that essentially has resulted in vague classifications of firearms. The vagueness has resulted in essentially issues of liability. Many police departments today don't use tasers, such as the Dallas Police Department, because of liability concerns. And many groups right now are prohibited from having firearms and therefore cannot use Taser 10. Some of these examples are tribal governments, correction officers, and emergency room security officers. Folks, we have to benefit, we have to harness all the benefits of the new technology behind us while maintaining strong guardrails to assure that we're moving ahead when it comes to public safety. This bill tightens definitions, clarifies conversion limits, and enhances Department of Justice oversight, along with a five-part test to make sure that these Taser 10s qualify. This bill, as Mr. Fitzgerald said, is stronger than last year's because we listened to both law enforcement and reform advocates. A minute ago, my colleague was talking about loopholes. Let me be clear. This legislation does not supersede any local state laws. Furthermore, this legislation does not prohibit individuals already barred from possessing firearms or ammunitions under 18 U.S.C. subsection 922G from having the ability to have these weapons. In other words, anybody who's barred right now, a felon from having these weapons, continues to be barred from having these weapons at their disposal. Chairman, I also want to recognize at this point members of our community who have come here in support of this legislation. I'd like you to ask you to please raise your hands, please. I spoke to these individuals before the hearing, and all of them have personal stories about tasers and how less than lethal force could have had different outcomes when it came to their personal stories. Thank you for being here today. Thank you for being part of this legislative process. And Mr. Chairman, with that, again, I repeat my strong support for this legislation. Thank you very much.
Gentleman yields back. Is there further discussion? Mr. Nails.
Yes, sir. Thank you, Mr. Chairman. Mr. Correa, well said, all of it. Everything you said, you are on target today, and I appreciate it. I'm an old law dog myself, old sheriff. What you said today was right on target. Thank you, ladies, for being here. Thank you. Also like to thank my good friend, Mr. Fitzgerald, for introducing H.R. 2189, the Law Enforcement Innovate to De-Escalate Act of 2025. This bill will establish a new less lethal category in law to prevent new tasers, models, and other less lethal devices from being improperly classified as firearms. It's less than lethal, folks. The new statute will provide police officers better tools in their day-to-day operation and provides congressional direction to the Department of Treasury and Department of Justice on a clear multi-pronged process for classifying less lethal devices. Importantly, this legislation clearly outlines that only less lethal devices qualify and screens out any devices not intended to be less lethal in support of the law enforcement mission with that five-part test, as Mr. Correa spoke about. As a former law enforcement official, I understand firsthand the crucial role that non-lethal devices play in protecting both law enforcement officers and civilians by providing officers with alternatives to deadly force when confronting physical threats. By allowing officers to subdue suspects without resorting to lethal measures, these devices help minimize the risk to humans to all parties involved. Officers need resources they need to perform their duties safely and effectively. Investing in new technologies, such as non-lethal devices, is essential to achieving better outcomes and enhancing public safety. This legislation, folks, it will save lives, positively impact communities, law enforcement, prisons, and healthcare facilities seeking more or less lethal capability. I urge my colleagues to support this bill, and with that, I yield back.
General yields back. Chair recognizes Mr. Raskin for a unanimous consent request.
Thank you very much, Mr. Chairman. This one is an article published by ABC entitled, "An Estimated 500 People Have Died from Police Use of Tasers Nationwide Between 2010 and 2021.
Without objection.
A second is a letter from Brady Community Justice Action Fund, Everytown for Gun Safety in Giffords, opposing HR 2189.
Without objection.
And finally, a letter from Catholics for Family Peace, Jewish Women International, Illinois Accountability Initiative, Just Solutions, Legal Momentum, and the National Domestic Violence Hotline, explaining that HR 2189 would undermine laws designed to keep weapons out of the hands of domestic abusers.
Without objection.
Mr.
Is
Chairman?
there further discussion on the amendment in nature of a substitute? Ms. McBath.
Thank you, Mr. Chair. And I'm truly very, very grateful to all of my colleagues on both sides of the aisle for trying to collaborate to come to some consensus and trying to save lives and keep our communities safe. And to those ladies and gentlemen that are here today, I'm really sorry that you have to be here. Thank you for being here to support this piece of legislation, but I'm sorry that you have to be here. I, too, have lost a loved one to gun violence, and so I take what we're saying here and doing here very, very seriously. But law enforcement officers serve as frontline support for every community, protecting, assisting, and ensuring public safety. That is why we must give them the tools to do that job effectively and safely. It simply does not make sense that we are considering a bill today that, in its true form, would put officers in great danger. Under current law, departments can already purchase a wide range of tools, including traditional firearms and so-called less-than-lethal weapons. And officers are trained to use tactics that prioritizes alternatives to deadly force. We must continue providing those resources and support that strengthens officers and community safety, not undermine them. This legislation was deemed dangerous nearly 3 years ago by the Department of Justice after review from prosecutors in the Criminal Division, the Executive Office for U.S. Attorneys, and firearms experts at the Bureau of Alcohol, Tobacco, and Firearms and Explosives. All agreed that this bill would endanger officers and communities by, and I'm quoting, weakening their efforts to keep weapons out of the hands of dangerous persons, end quote. The so-called Innovate to De-Escalate Act would, in reality, escalate the number of dangerous individuals who would be given a green light to legally purchase and possess hazardous weapons, despite clear evidence that they should be excluded. As the ATF warned, and I'm quoting again, these weapons could be used against law enforcement, security personnel, or the public, creating an increased risk of harm to public safety. They also would not be traceable if they were used in a crime, unquote. We rely on law enforcement officers every single day. They put their own safety and well-being on the line for us. Why then are we considering a bill that would expose them to even greater danger? It suggests that those voting for this bill are prioritizing increased profits for companies, including one that openly told investigators this legislation would, and I'm quoting again, open new markets over the safety of the people who protect us.
This bill has been deeply problematic for years, yet this committee continues to push for its passage. When the very agencies that work directly with law enforcement and prosecute criminals warns that this legislation needs significant work, we should take the reasonable and responsible steps of listening to them and working and massaging the bill until it's at a place and juncture where it makes sense and there's safety for everyone involved. We should strengthen this bill so that it actually protects our officers and our communities and the people that live in these communities, and it truly serves as a tool for de-escalation. Gun violence prevention groups worked in good faith to find a way to address the supposed need for this bill. They worked on this. They've all collaborated together while ensuring it does not subject law enforcement or people in the public to unnecessary risks. As a mother who lost her own son to gun violence, I understand. I understand exactly how you feel and where you are, but we have to make sure that we're putting forth legislation that really makes sure that it's protecting people in our community and protecting law enforcement as well. So I urge my colleagues to vote no on this bill and to call the sponsors of this bill to commit to improving the legislation. I will work with you to improve it so that we don't jeopardize the safety of our communities with this bill in the present form. Mr. Chairman, I have a unanimous consent request. I request unanimous consent to submit into the record a letter from Sandy Hook Promise in opposition to H.R. 2189.
Without objection. And the
And I thank you.
gentlelady's time has expired. Is there further discussion? Mr. Biggs.
Thank you, Mr. Chairman. I support the underlying bill, and I appreciate what Mr. Correa said. Spot on today, sir. You never thought you'd hear that from me, did you?
I did not.
I'm in total agreement with you, but let's consider this. The bill does not change any state-level restrictions. It just doesn't. So, state across the political spectrum, you got California, Florida, Pennsylvania, Wisconsin. They already define less lethal devices. They restrict possession by convicted felons and certain violent offenders and establish criminal penalties for misuse. For example, in Florida, using a taser against a police officer or during a felony is a serious criminal offense. This is an instrument that actually saves lives. Every year, there are more than 1,000 people who are shot and killed by police officers. More than 1,000. That does not include those who are shot and wounded by that lethal force. But when you use a less lethal force, everyone is safer. Everyone will be safer. This bill is supported by 90 bipartisan co-sponsors, so we've from 35 different states, the Fraternal Order of Police, major county sheriffs, National Organization of Black Law Enforcement Executives, Hispanic American Police Command Officers Association, and Peace Officers Research Association of California all support this bill. The African American Mayors Association, the Next Generation Alumni Leadership Council, Prince Jones Jr. Foundation, Coalition of Moms Against Police Brutality, all support this bill. This is a bill that will save lives. And I can't say it any better than what Mr. Correa said. And so I'm not going to belabor the point other than ask that these documents I have, Law Enforcement Innovate the De-Escalate Act, and Consumer and Law Enforcement Challenges, if they can be admitted to the record.
Without objection.
And I would urge everyone on this committee to actually, if you want to save lives, this is a bill you should be supporting. And with that, Mr. Chairman, I'll yield back.
Gentleman goes back. Is there further discussion? Mr. Johnson.
Thank you, Mr. Chairman. I rise in opposition to this legislation. It opens the floodgates for what's called non-lethal weapons to be sold on the streets of America with promiscuity. Everyone would be able to purchase one. And these non-lethal weapons are very serious in terms of the impact that they have on a human being. When you fire not a projectile, but a dart or whatever they call it, into a person, then you immobilize that person. And you're able to do to that person whatever you want to do to them while they are under your spell, under the influence of that electrical charge. And so that means that if that person against whom this charge is used is armed with a traditional firearm, is that person, if I see you coming at me with an advanced taser, am I able to defend myself with lethal force to prevent you from immobilizing me and then doing whatever you want with me? So, it's going to make us less safe for these weapons to be in the hands of everybody. And let's face it, law enforcement officers, law enforcement agencies are not barred from having these new style tasers. They can buy them. You got thousands sold to law enforcement agencies. Tens of thousands of these are in the hands of law enforcement to actually want to change the Gun Control Act to make it easier for law enforcement to purchase these weapons. That's not what this legislation will do. This legislation will open the floodgates so that these non-lethal weapons can be sold to everybody. Anybody would be able to get it. A child molester, a convicted, aggravated sexual predator, anybody, a felon. Any felon would be able to purchase this weapon. Anybody would have it, and it would have no serial numbers on it. It's untraceable. This is a step in the wrong direction. We should be trying to make the streets more safe than less safe. I support all law enforcement personnel having these tasers, these newly developed tasers. We need to make them broadly accessible. If finance is a problem, then maybe the federal government should help local law enforcement agencies to procure these weapons. It's in the public interest because I'd rather see a trained law enforcement officer using the taser instead of resorting to his traditional firearm, which is deadly. I certainly want them to have the option of less deadly force. But again, that's not what this legislation does. This legislation creates a loophole in the Firearms Act so that these non-lethal weapons can be sold to anybody, and they would be untraceable, and they would fall into the hands of minors. Anybody who wanted one could get one. And so we don't need to go down this route. I urge my colleagues to vote against this legislation, and with that, I yield back.
Gentleman yields back. Chair recognizes Mr. Correa for a unanimous consent request.
Thank you, Mr. Chairman. Unanimous consent to submit for the record a letter of support from our colleague, Benny Thompson.
Without objection. Is there
Chairman, I'll strike the last word.
Wait. Further discussion, Mr. Fitzgerald.
I just want to talk about a couple of the comments that were made. Because if I'm understanding some of my colleagues, these are arguments that we've heard before. It's kind of the argument that the unknown is the scary part of this. But in reality, consumer tasers represent just a small fraction of all tasers that are available, less than 1%. And even if you assume that somehow there'd be this consumer demand, there is an increase in the amount of states that have been watching this and have been enacting bills at both the state and local level that govern the use of less lethal devices. Many states already have age requirements for purchasing the devices as well. California, I think, Florida was brought up, Pennsylvania, my own state, Wisconsin, they already restrict possession and use by convicted felons and violent offenders. So that's another situation that I just don't see that emerging at all. And they also have established, many states have established criminal penalties for misuse. So, you know, I still think that at the end of the day, it's about law enforcement. It's about a new technology that is available now. And if we are going to make this move, then I think certainly you can have added debate and discussion about it, but at the end of the day, this is a bill that ultimately will save lives. And even if you're completely in favor of some type of gun control, this is an alternative that I think makes sense, and we should pass it in the Judiciary Committee today.
Does the gentleman yield?
I do. I yield.
Mr. Fitzgerald, I just want to state for the viewers that there's a very strong element of the crowd that is nodding in agreement with what you're saying, and I'm curious, do you know any of their stories or why they're supportive of this measure?
Actually, in the entire time that we've been working on the bill, I mean, some of the greatest supporters of this legislation are those that have been directly affected by some type of gun violence situation in their own life. And I've met with many of them over the last couple of years, and the stories are often similar, and that is, you know, if somehow there was an alternative to what was available to law enforcement, there may have been a different outcome. And it's always hard to kind of project on that, but I think that is something that's a common thread amongst everybody.
It's just noteworthy, and I'll address to Mr. Correa as well, that for the time of day to have this amount of support, all in agreement with what you all are saying is noteworthy, and it's not being conveyed to the cameras, but I did want to note it for the record, and I yield back.
Gentleman yields back. Is there further discussion? Mr. Garcia.
Thank you, Chairman. And to the sponsor of the bill and the advocates who are present here today, had a chance to meet with you outside and have a conversation. I truly understand your motivation, and individuals, loved ones who you have lost due to the use of deadly force by police officers. And I know that what you're looking for is a better alternative. And some of the arguments that have been advanced seem to make common sense, but I believe that the advancements and the promise in the technology are still not convincing enough for me, someone who wants to see a breakthrough in the number of cases where lethal force is used by police departments, and where in places like Chicago results in astronomical amounts of money being paid out to the families of victims who have been killed or severely injured by police officers. So I share that because the motivation of the advocates is very noble. You've seen, you have felt, and you're aware of dynamics in your communities, and you believe that this is an alternative. But I think some of the arguments and the evidence that's been submitted thus far gives us good reason for additional pause. I think that you may be on to something. I think that the technology is advancing and evolving, but I'm not at that point where I can be supportive. I tell you this in all sincerity as someone who has led efforts in my community prior to coming to Congress in the area of violence prevention and intervention. So I truly care about public safety and community safety as well. And I know that it takes a lot to come to a place like Washington, to come to this committee hearing, to wait for hours for an opportunity for a cause, an issue to be heard and I'm truly grateful that you are here today because you are making us analyze, you're making us take stock, and you are raising our awareness on perhaps something that we need to be acting in the future. But at this moment, I am not yet convinced. I appreciate the sponsor. I appreciate that there is some level of bipartisan support. But at the same time, I had to chime in after listening careful to all the arguments that had been advanced.
Gentlemen, yield.
Yes, sir.
Thank you. I just want to remind folks that tasers today save lives. This technology improves the distance that a taser can be used. Okay? These guests that are here today have their personal stories of where a taser could have resulted in a different outcome. Their loved ones possibly still be with us. And they're here because they know this technology works. There's safeguards built into this legislation. 5-part test, plus approval from the DOJ. Felons cannot buy these weapons. This technology will save lives. And I ask my colleagues that are in opposition to take a few moments. Go look at the technology. Go test this for yourselves. And make sure you understand what is really before us today. It's about minimizing, eliminating those ugly situations that happen between those in our communities that are challenged, that have mental issues, that have other challenges, and an officer possibly that comes to the scene, and he's got to make a choice. Lethal or non-lethal. This technology gives them another tool to go non-lethal. Remember that. Thank you, Mr. Chairman, and I yield.
Gentleman's time has expired. Is there further discussion? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no. The ayes have it, and the bill is ordered.
Ask for a recorded vote, Mr. Chair.
Recorded votes requested. The clerk will call the roll.
Mr. Jordan. Mr. Issa. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock.
Aye.
Mr. McClintock votes aye. Mr. Tiffany. Mr. Tiffany votes aye. Mr. Massey. Mr. Roy. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Klein. Mr. Klein votes aye. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes yes. Mr. Nels. Mr. Nels votes yes. Mr. Moore. Mr. Moore votes yes. Mr. Kiley. Mr. Kiley votes aye. Ms. Hageman. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Grothman. Mr. Grothman votes aye. Mr. Knott. Mr. Knott votes aye. Mr. Harris. Mr. Harris votes aye. Mr. Onder. Mr. Onder votes aye. Mr. Schmidt. Mr. Schmidt votes aye. Mr. Gill. Mr. Baumgartner. Mr. Raskin. Mr. Raskin votes no. Mr. Nadler. Ms. Lofgren. Mr. Cohen. Mr. Johnson. Mr. Johnson votes no. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Ms. Jayapal votes no. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Ms. Scanlon votes no. Mr. Neguse. Ms. McBath. Ms. Ross. Ms. Ross votes no. Ms. Ballant. Mr. Garcia. Mr. Garcia votes no. Ms. Kamlager-Dove. Mr. Moskowitz. Mr. Goldman. Ms. Crockett. Mr. Jordan. Mr. Jordan votes yes. Mr. Fry. Mr. Fry votes yes.
How is Mr. Nadler recorded?
Mr. Nadler is not recorded. Mr. Nadler votes no. Ms. Kamlager-Dove is not recorded. Ms. Kamlager-Dove votes no. Mr. Gill, you're not recorded. Mr. Gill votes yes.
Clerk will report.
Mr. Chairman, there are 18 ayes and 8 noes.
The vote being 18 in the affirmative and 8 in the negative, the ayes have it. The motion is carried. The bill is ordered, reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Without objection, the committee will stand in recess pending call of the chair.
Regulation Act of 2025 for purpose of a markup, and move the committee reported favorable to the House. Well, no, I've got the wrong. Yeah, that's right. Clerk will report the bill. 26. Make sure I got the right one.
H.R. 2675, a bill to amend Chapter 111 of Title 28.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Virginia, Mr. Klein, for an opening statement.
Thank you, Mr. Chairman. I'm pleased to introduce H.R. 2675, the Protecting Our Courts from Foreign Manipulation Act. This bipartisan legislation addresses a serious threat to the integrity of our judicial system by foreign actors who engage in lawfare against U.S. individuals and businesses for nefarious purposes. Due to the lack of reliable disclosure requirements today, foreign states with adversarial interests can secretly fund lawfare against U.S. individuals and businesses to harass or intimidate Because neither the courts nor many of the parties may be aware of their involvement, these cases also represent opportunities for foreign interests to misappropriate proprietary information and technology. For example, a foreign adversarial government may seek to benefit its national champion by providing funding to a patent assertion entity to engage in a litigation campaign against a key U.S. competitor. If that U.S. company is unaware of the involvement of the foreign government, it will not know that the lawsuit's intended to benefit its foreign competitor. It will not know that the plaintiff's lawyers are secretly being paid by that foreign government, and it will not know that it has to seek extra protections from the court to ensure that its confidential technical information does not fall into the hands of its competitor during discovery. If the court is similarly unaware of the foreign government's involvement, it will not know to scrutinize the plaintiff's discovery requests or to issue extra protections in its protective order. The secret involvement of foreign states in our legal system puts our citizens and companies at risk, clogs our courts with improper lawsuits, and exacerbates the disparity between the fair treatment in U.S. courts and the unfair treatment of our companies and citizens in litigation abroad. This legislation would curb these practices. It would require at the outset of litigation the disclosure of any foreign person, state, or sovereign wealth fund, other than an actual party to the suit, that is providing monetary support. This disclosure requirement applies to all such arrangements, including those that are contingent upon prevailing in court, and regardless of whether the recovery is a damages or fee award through a judgment or settlement. The bill contains related provisions requiring party certification and production of documents pertaining to the disclosure, and it makes the failure to disclose subject to litigation sanctions. Most importantly, H.R. 2675 prohibits third-party litigation funding arrangements in which a foreign state or sovereign wealth fund is a source of the funding. Finally, H.R. 2675 requires the Department of Justice to report to Congress on the identities and sources of funding in federal cases where foreign-funded cases are litigated, the total estimate of foreign money in federal litigation, and the types of cases that are funded by foreign sources. These robust provisions will help put an end to foreign abuse and lawfare. Please join me in supporting this bill to protect American citizens and our private sector. I yield back.
Gentleman yields back. The chair now recognizes the ranking member, Mr. Raskin, for an opening statement.
Chairman, thank you very much. You know, when I first saw this one, I could hardly believe my eyes because I had just been reading an article about Donald Trump's $400 million airplane that he received as a gift from the Qatari government. And of course, this committee knows about the tens of millions of dollars that he's received in unconstitutional foreign emoluments, which violate Article in Section 9 from Saudi Arabia, United Arab Emirates, Indonesia, Egypt. We've released reports on all of this stuff. So this bill is now targeting, if I understand it right, financing, third-party financing of litigation that either directly or indirectly, whatever that means, comes from any foreign source at all. And these are entities that actually have a right themselves to go to court in America. So it's hard exactly to see why there should be a ban on their being involved in other litigation. Don't we just leave that up to the market? I mean, certainly that's Donald Trump's solution, and he's violating the Constitution directly. I think I picked up the newspaper yesterday. His family is now going into business with the Saudis again for billions of dollars in terms of some development in Saudi Arabia. And anyway, look, today's two bills instituting so-called transparency measures into third-party litigation funding are obviously nothing more than giveaways to big corporations that don't want to be held accountable when their actions violate the law and harm people. Third-party litigation funding is perfectly lawful, it's perfectly normal, and it's perfectly consistent with the rules of professional conduct and ethics. And if anybody uses it in a way that violates the law or those rules of ethics, they can just take it to court. Today, there's really no problem. Third parties invest in litigation, by the way, for liberal groups, centrist groups, and right-wing groups. I'm going to distribute a letter to all my friends from the Tea Party Patriots when we get to the next bill, where we've got some of the most distinguished conservative and MAGA lawyers in the country opposing the Litigation Transparency Act. Ken Blackwell, the former treasurer of Ohio, is going to be opposing that one. Tim Jones, the former Speaker of the Missouri House. Stephanie Smith from Alabama, I think in Representative Moore's district. On and on. These people understand how dangerous this is, right? Third parties invest in litigation in return for a share of the contingency fee or the damages awarded should the party they've invested in win the case. This is a practical, market-based solution to the problem that the majority of Americans face when they think about going to court to obtain justice against a deep-pocket defendant. Litigation is extremely expensive, and deep-pocketed corporate defendants will try to spend you into oblivion rather than give you the opportunity to win in court. Third-party litigation funding helps ensure that nobody, the little guy, the middle guy, the big guy, left, right, center, is denied their day in court simply because of financial obstacles and barriers. And it works. People who couldn't afford to get their court heard have been able to overcome major financial obstacles with the help of third-party investment. But because third-party litigation funding helps ordinary citizens take on the big guys, it's become a target for big business groups that would much prefer that people not have the ability to bring lawsuits against them. These businesses and other corporate interests want you to believe that these agreements are somehow dangerous or nefarious. They suggest that actually third-party funding is somehow giving ordinary people an unfair advantage against large, powerful corporations that can purchase all of the legal help that they want. So now these parties have proposed a bill that they would say brings transparency to the system. In reality, today's bills would impose a form of abusive transparency and use it as a tool to dissuade funders from participating in third-party litigation funding agreements. Forcing litigants to disclose private investors would undoubtedly have a chilling effect on TPLF usage. If this is somehow a foreign policy matter, a matter of national security, how come we're not hearing from the State Department? How come we're not hearing from people interested in foreign policy? I am delighted that my colleagues have an interest in what foreign governments are trying to do to influence us here in America, but I can guarantee you it's got nothing to do with foreign sources indirectly affecting parties whose causes of action must be adjudicated by American judges and juries. It has to do with direct payoffs to the President of the United States, like the $400 million Qatari airplane and the millions and millions of dollars that were spent on rooms never used at the Trump Hotel by the Chinese government and by the Saudis and United Arab Emirates and so on. So all I can say is if we want to have a hearing about illegitimate foreign influence in America, let's do it. But this is an extremely attenuated Rube Goldberg contraption to try to get at it. I'm going to oppose both of these bills today. I'm really going to encourage my colleagues to check out the letters pouring in, not just from liberal public interest groups, but from conservative public interest groups saying, do not go down this road. I yield back to you, Mr. Chairman.
Gentleman yields back. Without objection, all of their opening statements will be included in the record. Chair now recognizes the gentleman from Virginia to offer an amendment in nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to HR
Move to waive the reading.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of amendment. The chair now recognizes the gentleman from Virginia to explain the amendment.
Thank you, Mr. Chairman, and I want to thank the ranking member for combining his two statements in opposition to the first bill now and the next bill down the line so that we don't have to hear another speech down the line. A lot of what he said doesn't relate to this bill, but let me just get into the details of this amendment in the nature of substitute. This amendment makes minor changes to clarify the bill's provisions to prevent gamesmanship and also provides additional relief to U.S. individuals or companies who were targeted by foreign actors. As amended, the bill would now prohibit providing or receiving monetary support from a foreign state, even in the absence of a formal agreement, and clarifying language has been added to the definition of sovereign wealth fund to avoid confusion or gamesmanship. The bill as amended would also require disclosure of the identity of a foreign source of monetary support, even absent a formal agreement, creating contingent rights. Additionally, this amendment adds a provision that lawsuits in violation of the prohibitions against foreign state funding are to be dismissed, and further provides that a party targeted by such a lawsuit can retroactively obtain relief from the judgment if the violation is only discovered later. I urge my colleagues to support the amendment, and I yield back.
Gentleman yields back. Who seeks recognition? The gentlelady from North Carolina is recognized.
Thank you, Mr. Chairman. I just want to say that I strongly oppose both this bill and H.R. 1109. I think they're both overbroad. They will have unintended consequences, though part of me thinks that they are intended consequences. These bills are not about transparency or national security. They're about making it harder for workers, consumers, patients, and survivors to hold rich and powerful entities accountable in court. They were written to give corporate defendants a new strategic weapon, insight into the financial resources of the people suing them, so that they can drag out litigation and force families to give up or settle for pennies on the dollar. In North Carolina, when families are poisoned by PFAS in their drinking water, or when a defective product harms a child, or when a worker is injured by corporate negligence, they should not lose their day in court because Congress decided to tip the scales even further toward the defendant. These two bills force disclosure of third-party litigation funding to corporate defendants, not just the judge. This is a crucial distinction. Today, judges already have the authority to review litigation funding arrangements to make sure that they are fair, ethical, and lawful, without handing a corporation a roadmap to the plaintiff's financing. The plaintiff doesn't get that roadmap to the corporation's financing. These bills add nothing to judicial oversight. They just hand sensitive information over to a powerful party. Third-party litigation financing is often the only way that an ordinary worker or consumer can bring a complex case. Cases involving toxic pollution, defective products, corporate fraud, widespread discrimination. It routinely requires millions of dollars in upfront costs for experts, discovery, and years of litigation. And these cases have become even more difficult to bring because the courts have made it more difficult to have class actions and nationwide injunctions, therefore making each and every litigant responsible for their attorney's fees. In North Carolina, we've seen communities along the Cape Fear River and other rivers forced to fight back against PFAS contamination. Rural communities taking on powerful agricultural and industrial polluters, and these families do not have corporate legal budgets. They rely on lawyers, who in turn rely on financing to stand toe-to-toe with the defendants. By choking off litigation financing, these bills would make it harder for families and injured parties to be able to challenge wage theft, unsafe products, nursing home abuse, toxic pollution, and so much more. And once the large corporate defendant knows the plaintiff's financial runway, they can strategically delay a case, engage in abusive discovery tactics, and drive up the costs. Even knowing that a plaintiff doesn't have a funding agreement can be weaponized, signaling to a corporate defendant that they can stall until the worker or survivor runs out of money. And to this bill's point, the claims about foreign interference in our justice system simply don't bear out. If we were generally interested in foreign sovereign wealth funds influencing U.S. litigation, the logical solution would be to carefully target disclosures to just address national security interests, not forcing a sexual assault survivor or a worker with wage theft claims to open their financing arrangements to the corporations they're suing. For all of these reasons, I'm strongly opposed to this bill and the other bill that we're supposed to hear, and urge my colleagues to stand with everyday Americans and not powerful entities seeking to evade justice. And I yield back.
Gentlelady yields back. The gentleman from Arizona is recognized.
Thank you, Mr. Chairman. I'm intrigued by the conflation of this bill with the ISA bill, which I think are actually very different things. This bill is dealing with foreign intervention in American litigation. And if we don't put something on this, we're going to continue to see a whole host of perverse incentives to come in. The argument so far has been, well, you have this defendant who's funded by a third party who's going to come out and just basically stall and drive the plaintiff into bankruptcy. This bill also prevents plaintiffs. So let me give you an example. This isn't hypothetical. This is in 2024. Sanctioned Russian billionaires created an investment fund to back bankruptcy lawsuits in New York, allowing oligarchs to steer tens of millions of dollars into Western financial institutions when they'd been sanctioned. They used that litigation to get around the sanction. Another instance, these are all reported in Newsweek, by the way. China-based technology firm Purple Vine financed several intellectual property lawsuits against Samsung that would not have been discovered except a lone judge who was watching over the case, who had jurisdiction over the case, happens to choose to require litigation financing disclosure in his courtroom. If that hadn't crossed the desk, the defendants never would have known that their case was hardly a mere legal challenge, but in actuality a case of national security importance. That's what this bill is designed to protect against. You can go on. Another case that was reported, getting around FARA filings. An Australian mining billionaire was paying legal bills for a coalition of environmental nonprofits in their lawsuit against ExxonMobil. It was only through looking at FARA disclosures that anybody found out that it was a third party from a foreign entity inciting litigation in our country. We're not even talking about the potential for frivolous claims that can be funded by a foreign entity. We're not talking necessarily even about the intellectual property that can be ripped off. So I think this is misplaced. How about this? Further analysis in the Newsweek, this one Newsweek article, and I'm going to submit it, and there's a whole host of other articles that I will probably submit. I don't want to weigh this down, but the hidden party industries, which this is called, is growing at a pace of about $17.5 billion in 2025, and by mid-2030s will grow in excess of $67 billion. And that's because they're pushing lawsuits that you otherwise wouldn't be bringing that's being funded by foreign entities. So when you start talking about, oh, they're defending and protecting these big bad corporations, you're forgetting that there's also an incentive for plaintiffs to do the same. So that's, Mr. Chairman, I would introduce that Newsweek piece called "We Must Protect American Courtrooms from Foreign Interference."
Without objection.
And also, the U.S. Chamber of Commerce has brought this out as they're calling it TBLF, particularly with regard to foreign entities. I would like to submit that. Theirs is, thank you.
Well, gentlemen,
the point is ultimately, I get your issues with the other bill. I may actually share some of those issues. This bill, I think, is a vastly different bill. I think it is more narrowly crafted, and I think it is designed better and it's clearer. But if you're going to argue unintended consequences, if this bill doesn't pass, you're going to see a continued growth in third-party foreign entities in our litigation for a whole host and myriad of reasons, not the least of which is theft of intellectual property, trying to get around our laws and sanctions, just like the Russian billionaires did in 2024. And with that, Mr. Chairman, I'll yield back.
Gentleman yields back. Gentleman from Maryland's recognized.
Mr. Chairman, thank you. And I appreciate the remarks of the preceding member. It seems to me that what happened in the case that you're describing is exactly what ought to have happened. That is, if the claim is made that the client of a particular lawyer is no longer or never was controlling the case, and that is a fake client and a proxy for someone else, then you make a report to the judge. You file a complaint and you say, hey, I don't think this is real litigation. I think it's being controlled by a third party. The third party may be paying for it or not. They might be domestic, they might be foreign.
The gentleman yield for a second?
Well, let me just complete the thought and I'll come right to you. And so, therefore, they went to the judge. They raised the point that there was an absentee third party who was actually controlling the litigation, and the judge had complete power to work it out, to demand disclosure, and so on and so forth. That could have happened with a domestic corporation. It could have happened with another domestic person. It could have happened with a foreign private corporation, foreign state, what have you. And we do want to prevent that because of the rules saying that you've got to follow your client's wishes and not that of some other third party. So I don't quite see what the problem is there. I mean, is there some general problem? Because, what I want to raise is the real problem of money going directly to American public officials, including the President of the United States, directly from foreign states or indirectly from foreign states in their companies, and then putting in their pocket. I don't quite see what the issue is with, say, a foreign state who invests in a business, and that business makes loans to people, and a loan is taken out by a law firm to bring a case based on some cause of action, which a judge is going to consider, which a jury is going to consider, and I'm not quite sure exactly how that contaminates our legal process, but I'm happy to yield.
Yeah, thanks for yielding. I'm not sure that we're reading what transacted in the Purple Vine case the same way. That wasn't Chinese companies that necessarily invested in American companies as a front. What that was is they financed lawsuits against Samsung so they could get intellectual property as discovery. You see, that's really part of the issue that comes up here. And the other one is you're concerned you didn't address.
Well, if you would just pursue that for a second, okay, and that violates what law or what rule of ethics or rule of professional conduct? In other words, if, say, all these conservative groups that are writing in and say they get a donation from, some other source that's interested in their winning a case, what rule of professional responsibility does that violate?
Well, what I will tell you is if a Chinese Communist Party is funding going after U.S. intellectual property through litigation because we have this open system, maybe protection of our national security interest is important. How about you didn't?
I thought you were talking about compromising the integrity of the judicial process. In other words, that's just back to a bland abstraction, national security, and I'm not quite sure I see what it is. I mean, if we want to say the Chinese government, the Russian government, none of these governments can ever sue in American courts, fine. But if we're not saying that, if we're allowing them to sue, what's the problem with them contributing money to somebody else's suit and the judge having the opportunity to force disclosure?
Mr. Chairman.
And I'm happy to yield also, because it's an honest question.
Well, I appreciate the gentleman's question. Courts can't police what they can't see. And so what you have are the structure of third-party litigation funding often being made to conceal the true source through layers of intermediaries, and the judge, the court, doesn't recognize they don't have the information needed to protect the integrity of the proceedings. This would provide that disclosure and provide that information so the judge can make the choice and can make a better decision.
Okay, right. But this bill forces the disclosure to the corporate defendant, not to the court, as in the case we just discussed, right?
This bill targets only foreign states and sovereign wealth funds. It doesn't target private investors or domestic funders. It is designed to target foreign third-party litigation funding. So it's not just to one entity, it's to both.
Okay.
If the gentleman would
please.
Let me just ask this. If you believe that in the Purple Vine case that's exactly how it should have happened, how would the judge have known, but the judge was extraordinarily vigilant? Because it was not disclosed. The judge was looking at things that there's something going on here, finds out, and if you're okay with the judge finding out and saying, wait, we got a problem here, then why not codify that process in law, which is what this bill does?
Okay, thanks. I think my time is up.
Sorry.
The gentlelady from California is recognized.
Thank you, Mr. Chair. It's, interesting because I read these bills with a layman eye, as I am not one of the many attorneys on this committee. But I am going to oppose this bill for a number of reasons. And I read it and had just so many questions. First, and I appreciate Congressman Biggs sharing a couple of instances from this Newsweek article, but I'm still wondering how many times has this happened? How many documented instances, especially compared to the number of cases that are filed in our courts? I mean, is it disproportionate, the instances that this has happened? And how often or in what way did the financing impact the verdict? And in what way? Because, I think ultimately what we would be interested in is the merit of the case and the verdict. And my understanding is that attorney-client privilege precludes the sharing of financial information of any nature. And so how are we now going to abrogate attorney-client privilege? The other thing I thought is that litigation is private, and your litigation strategy is private. What's public is the contested issue, and the merit of the case is the issue in question or should be all the time. My reading of this is that the bill would want to sanction witch hunts to nullify verdicts that were lawfully obtained because of, in spite of, financing. And this bill also presumes that foreign money has a nefarious influence. But if you're going to be honest, if that is the case, I don't know. But let's also presume that domestic money can be nefarious at times. This bill, in my opinion, uses national security as a convenient cloak to screw the little guy. And there are so many of my colleagues on the other side of the aisle who were talking about protecting the little guy, especially as it relates to the Epstein files. Oh, what about the little people and, having their names exposed? This is also a way to screw those little people. Folks who are courageous enough to sue big corporations are going to get snuffed out under this bill because the large firms actually have the time and the resources to drag out litigation. And they're going to continue to have the upper hand under this bill. And the other kind of twisted irony is that many of the large corporations that we now talk about are multinational corporations, and they are making their money because of foreign investment and foreign money. And this isn't holding them accountable. I think about Tesla. Tesla has a war chest of money, and they get a ton of foreign investment. So they actually, according to this, you could argue, have a legal war chest from foreign financing to help them win their lawsuits against plaintiffs, against workers, against consumers, or anyone who's going to be bold enough, I guess in this instance now, if this bill were to pass, silly enough to try and sue them because they've been wronged. And then the other question I have is about enforcement. So are we now going to create a whole subsection under DOJ devoted to investigating foreign financing? I mean, what about the DOJ supposed to be working on the human trafficking and the cartels and all the bad stuff? And so now you're going to dedicate a group of people to go into all of these litigant cases to kind of figure out where people are getting their foreign financing. That doesn't make any sense to me. So so much. And then I have to say, I was like, ooh, how many lawyers are on here? And quite a few. And the resumes among you all is impressive enough to confirm that you know the hypocrisy of this bill. So why we continue to let truth get in the way of tribalism, I don't know. But I'm going to have to oppose this bill. And I yield back.
Mr. Chairman.
Lady yields back. The gentleman from Virginia is recognized.
Oof, there was a lot, move to strike last word. There was a lot said there, but let me just say, when you're talking about the little guy, the Chinese Communist Party is not looking out for the little guy in America. The Chinese Communist Party is looking out for the slave wage Uyghurs who are making their products that are competing with the American little guy. And the American little guy is over here trying his best to make a living and is being undercut by intellectual property theft from Chinese agents who are funding these types of litigation. You know, the foreign governments are not ordinary market participants. This bill does not affect private litigation finance. The only entities barred from funding these U.S. lawsuits are foreign governments and their financial arms. These, as the ranking member said, pose unique national security and influence risks. When a foreign state funds litigation against U.S. companies or individuals, it opens the door to strategic manipulation, geopolitical manipulation, access to sensitive information during discovery, and the courts don't know. When you ask for numbers, it's happening. It's a multi-billion-dollar industry, and the courts don't know it's happening. So we're just looking for basic information for the courts so that they can protect the integrity of the proceedings and the integrity of the American system and the rule of law, which should be protecting the little guy that you speak of. So that's why this bill is being introduced, and I just want to clear the record on that. So,
would the gentleman yield for a question?
Well, I'll be happy to yield after I yield to Mr. Biggs.
Thanks, Mr. Klein. I just want to cover just, again, a couple of the quick points of reported cases, because I get the question. I think it's a fair question to say, how big a deal is this? It's an estimated $16 billion deal. That's a pretty big deal. And while in our colloquy that the ranking member and Ben and Mr. Klein and I had, we talked primarily about the Purple Vine case, but we didn't ever get back to the 2024 case of the Russian billionaires who created specifically an investment fund because those Russian billionaires had been sanctioned by the U.S. government, right? So they created a fund so that they could back bankruptcy lawsuits in New York, which allowed them to actually then launder money through the bankruptcy proceeding and get that money into Western financial institutions, thus getting around the sanctions that our own government had placed on them. So the fact that we learned about that is almost just serendipity. But this bill is basically designed to say, look, if you're a foreign government or you're a foreign government's sovereign wealth fund, you got to disclose. Failure to disclose means you lose. That isn't protecting the little guy. In this instance, you had the Russians going around our law. And in the Purple Vine case, it wasn't a little guy that would have been protected. It was Samsung. Samsung was in this litigation, and they're getting their intellectual property ripped off by the Chinese Communist Party. And in the other one, it wasn't a little guy. It was ExxonMobil who was being attacked by a billionaire who owned mines in Australia, who was funding lawsuits because he wanted to change policy within Exxon. That's the point. I understand it, and the mentality where you say, well, it's the little guys, because I get that, because we're seeing this right now. And quite frankly, in personal injury cases, which deals not with this case, this bill, but with the next one, in personal injury cases, what you're seeing now is something very different. This is where you're actually seeing loans being made by third parties to potential plaintiffs, the injured, right? That's very different than what this bill is getting at. That's why I think it's totally different. And then when the ranking member is bringing up these folks who oppose it, I happen to be with you on that. I don't like the other bill. But it's not this bill, which is very different. And I'll yield back to you, Mr. Klein. Thank you.
And I'm happy to yield to the ranking member.
Well, yeah, so if this were a bill then saying that that people or governments that have been sanctioned by the United States government either are banned and prohibited, or it must be disclosed. That makes sense. I thought the first compelling argument I really heard, that they were using litigation as a way to launder their money through the bankruptcy process. But I guess what I'm looking for is, what is the danger of, I mean, I'm assuming that these are just wealthy, you're banning the sovereign funds, right? But you're saying other governments can do it if it's disclosed. Is that right?
That it has to be disclosed if a foreign government is.
Yeah. So one question about that. How does the judge determine whether there's a national security risk and therefore prevent them from participating?
Well, it doesn't have that.
So it's not
in the bill. That's
okay. So it's not really about national security then. But then what is it about? If it's not, I mean, you're saying even if they were a national security risk, we're going to let that go. Well, what's the issue? And that's why I come back to the linkage between these two bills, because it's just really making it more difficult for people to get money if there are these international funds that have decided investing in American litigation is, through some other entity, is a lucrative way to invest. Maybe we want to fundamentally change our legal system, but that is our legal system, right? And so people need money in order to go to court. And I'm not quite sure why, if the American judges and appeals courts and juries are in control, how it's a threat to our judicial system to allow them to invest in the litigation.
It's one thing if it's a foreign interest. It's another thing if it's a foreign government. And
because
I think why?
But how does it influence?
We don't want foreign governments influencing our judicial system with multi-billion-dollar lawsuits.
Mr. Chairman.
Okay.
I've run out of time, Mr. Chairman.
Mr. Chairman.
Gentlelady from Washington is recognized.
As I read this bill, though, the prohibition applies only to foreign governments, sovereign funds, but the disclosure applies to private funders as well. And so that's why, to me, the effects of these two bills are the same. And the concerns that we are raising around the second bill applies here too, because the disclosure requirements are not just foreign governments and wealth funds. It actually says person here. Name, address, and if applicable, citizenship or the country of incorporation or registration of any foreign person. So this is, the effects of the two bills are the same, and I think at the end of the day, it is about the little guys with a lot fewer resources that are facing big, powerful corporations. And I think you end up in a situation where the cost barrier alone determines who wins and who never gets hurt, and you end up disallowing workers and consumers and victims and survivors and small businesses any kind of a fighting chance. So to me, the two bills are the same in their effect. And lawsuits that wouldn't have been possible without third-party litigation funding, and here I'm talking about the second bill, but they include mothers suing a pharmaceutical company for cancerous baby powder, families of victims of school shootings, suing a gun manufacturer for marketing AR-15s to teenagers, small inventors suing large companies for stealing their creations, female employees suing an insurance company for discriminating against them through lower pay and fewer promotions. So even though you're making the distinction here, it seems to me that your bill is not, the prohibition is the only part that applies to state. I don't know if you want to, I'm happy to yield.
Well, Gentlelady, yield. Thank you.
Yeah.
I would just say that the Chinese Communist Party is not going to be the entity that is engaging in this funding. It is going to be using proxies. It is going to be using, it is, when you see Huawei engaged in this type of third-party litigation.
But this isn't Huawei, this is
No, you're talking about the second bill.
This is no, I'm talking about your bill.
Okay, well, yeah.
I'm talking about your bill on
They also
page
use
4.
proxies
It says
and individuals, and I mean, the
Okay, but
Chinese
then-
Communist
but-
parties will.
Reclaiming my time, but then there's no distinction. You're trying to make a distinction between the state and sovereign wealth funds and private individuals, but you're
trying to get at the
yourself
problem.
saying that there's no distinction here because you're saying that those foreign governments might fund through private individuals, but then you're collapsing the distinction right there. So it's not, I mean, I think I think that, again, the effects end up being the same, and I think that's why for those of us who are concerned about these bills, we want to make sure, and I think my colleague from Arizona mentioned this as well, but I think that we want to make sure that the little guy does have the ability to fight back. And so I just, I want to address the myth that third-party litigation funding encourages the filing of frivolous lawsuits. That's the effect of both of these bills, I think. Funders provide money on a contingency basis, meaning that they're not going to recover the loan unless and until the victim's case is resolved in a way that allows the victim to pay back the loan. And these funders finance cases because they believe the cases are meritorious and they have the high likelihood of success. Otherwise, they would lose the money that they lend to the victims. I had this comment for the second bill, but I don't know if we're going to get to that bill. So I'll just say that I also find it somewhat rich that my Republican colleagues ended the government shutdown last week, denied 22 million Americans the ability to stop health insurance costs from going up, but at the same time gave 8 of their Senate Republican colleagues the opportunity to sue the government, get millions of dollars in taxpayer-funded payouts in court for subpoenaing their records as part of the January 6th insurrection investigation. That's something that no other American gets to do, and it feels to me like that's just more rigging of our justice system to benefit them, but not you. So it's fine for them to sue, but not you. And with this bill, I think with both these bills, there's a real attempt here to stop the little guys from holding corporations accountable. So I'm a no on both these bills.
Gentlelady yields back. Gentleman from New York is recognized for, I think, an amendment.
An amendment, yes.
Gentleman from Maryland is recognized.
The amendment is at the desk.
Report.
And
Point of order been reserved. The clerk will report.
Amendment to the
Without
amendment.
objection, the amendment will be considered as read. The gentleman from Maryland, the ranking member, is recognized to explain the amendment.
the amendment compels disclosure in the interest of transparency of all the donors to the new White House construction project. The president has refused to disclose the donors, and he's also refused to say that they will not be either corporations or foreign governments or states or foreign government and foreign state sponsored entities. And so this just follows in the train of what we're saying. And if we can add this, I think it will put our side to the test. It will put your side to the test. And so if you guys can vote for this, it might be a little too much to vote twice against something that would not necessarily be Donald Trump's first choice waking up, but that's all about being the Article I lawmaking branch. If we think that the White House should be constructed either with public money, or if we're accepting contributions, the public's got a right to know who's contributing and what they're getting out of that, then this is the amendment for you. And so I submit that to the wisdom of the group, and it certainly follows from everything we're saying about not compromising national security and not compromising the integrity of essential public functions.
We will give you our wisdom, but we'll start with the gentleman from Arizona. Does the gentleman insist on his point of order?
I do, Mr. Chairman.
The gentleman is recognized to explain their point of order.
I think the gentleman's amendment would introduce material that is beyond the scope and purpose of the bill before us. It violates House Rule 16, Clause 7, and I'll yield back.
Gentleman yields back. The gentleman from Maryland wish to
it goes
decline as well.
Yeah, I would just say this goes right to the heart of the legislation, at least as it's been recommended to us, which is that it's all about preventing illegitimate foreign influence and control over American governmental process. And that should apply whether we're talking about the legislative process, the judicial process, or the executive branch. And there's been a lot of rhetoric about national security and protecting our national security. It's hard to see what could compromise our national security more than foreign state donors to the construction of the American people's White House. So I definitely would challenge that and ask for an adverse ruling there.
All well and good, but that doesn't change the fact that the gentleman's amendment does not satisfy the subject matter and fundamental purposes test. Therefore, it is not germane and is out of order.
And can we appeal the ruling of the chair and just take a quick vote on that?
I move the table of appeal.
There's been an appeal, there's been a move to table. The question is on tabling the appeal from the gentleman from Maryland. All those in favor say aye. Aye. Those opposed, no. No. The ayes have it, and the question now occurs on...
Can we just have a recorded vote on that one?
We can have a recorded vote on that. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Isa votes aye. Mr. Biggs?
Aye.
Mr. Biggs votes aye. Mr. McClintock? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Gill votes aye. Mr. Baumgardner? Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? Ms. Lofgren? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Moskowitz votes no. Mr. Goldman? Ms. Crockett?
Gentleman from New York?
Mr. Nadler votes no.
Clerk will report.
Mr. Chairman, there are 14 ayes and 10 noes.
The tabling motion, the ayes have it, the tabling motion is adopted. The question now is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chairs, the ayes have it. The amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. In the chair, the ayes have it.
Can we have a recorded vote on that?
Yes, we can. The clerk will call the rule, or call the roll on the legislation.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Grothman? Mr. Grothman votes aye. Mr. Knott? Mr. Knott votes aye. Mr. Harris? Mr. Harris votes aye. Mr. Onder? Mr. Onder votes aye. Mr. Schmidt? Mr. Schmidt votes aye. Mr. Gill? Mr. Baumgardner? Mr. Raskin?
No.
Mr. Raskin votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Johnson? No. Mr. Johnson votes no. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? No. Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Moskowitz votes no. Mr. Goldman? Ms. Crockett?
Could I be recorded as an aye, please, Mr. Isa?
Mr. Isa is aye. Mr. Kiley, you're not recorded. Mr. Kiley votes aye.
Clerk report.
Mr. Chairman, there are 15 ayes and 11 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of substitute, incorporating in all adopted amendments, and staff is authorized to make technical and conforming changes. Unfortunately, I have to get to an event. So the committee will stand in recess until 12 o'clock noon on Thursday. We have subcommittees tomorrow, so we do have a couple of the bills we'd like to get through. Unfortunately, we just have the time this evening. So we will see you, if you're not on the subcommittees tomorrow, we will see you Thursday at noon. And with that, we stand in recess.